Hey folks, Katie Phang here at the Katie Phang News Channel. We just got the breaking news that the United States Supreme Court has upheld a Tennessee state law that did not allow for transgender care to be provided to minors. And I wanted to walk through that decision with you in real time. And again, the breaking news being the Supreme Court upholding a Tennessee ban on transgender youth medical care. And so we're going to walk through that opinion in real time. Hopefully this provides some value to you, but I appreciate your patience as we do it together. It is case number 23-477. Just a reminder, we have been waiting for about 21 decisions to be released by the United States Supreme Court. If you caught a Substack Live I did with Steve Vladeck about a week ago and some change, Steve noted that because of the unusual number of emergency applications that have been done by the Trump administration, they have far exceeded any prior administration in terms of emergency applications to the Supreme Court of the United States. There has been a backlog of opinions to be released on the regular docket. Keep in mind, the United States Supreme Court has a regular audit of cases that it has agreed to accept, to hear, and to render a decision upon. And because the Trump administration has just been hammering the Supreme Court with emergency applications, there has been a delay. So we've been waiting for a lot of important opinions, including this one. Straight out of the gate, it is a 6-3 decision, split on ideological policy lines, right? We've got 6 conservative justices, the uber conservative majority of the Supreme Court, the 6 of them, and then the 3 liberal, quote unquote. And, listen, I don't go for the labels, but they clearly apply with the Supreme Court. 3 liberal justices, Sotomayor, Justice Ketanji Brown Jackson, and Justice Kagan in the dissent. Chief Justice John Roberts delivered the opinion of the court. The consideration or the question in front of the court was whether a Tennessee law banning certain medical care for transgender minors violates the Equal Protection Clause of the 14th Amendment. The immediate ruling from the court is the following in terms of a summary. And it says here, the court's role is not to judge the wisdom, fairness, or logic of Tennessee SB 1, which is the law at issue here, but only to ensure that the law does not violate equal protection guarantees. It does not. Questions regarding the law's policy are thus appropriately left to the people, their elected representatives, and the democratic process. Okay, so let's very quickly go through the majority opinion here, because the analysis is what we're trying to look at. So here we go. The decision that was before the Supreme Court is whether Tennessee law SB 1 violates the Equal Protection Clause of the 14th Amendment. So let's start with the Equal Protection Clause of the 14th Amendment. The 14th Amendment's command is no state shall deny to any person within its jurisdiction the equal protection of the laws. It must coexist with the practical necessity that most legislation classifies for one purpose or another with resulting disadvantage to various groups or persons. If a law neither burdens a fundamental right nor targets a suspect class, we will uphold the legislative classification so long as it bears a rational relation to some legitimate end. We generally afford such laws wide latitude under this rational basis review, acknowledging that the Constitution presumes that even improvident decisions will eventually be rectified by the democratic processes. So that is the first paragraph in Section 2 of the majority opinion. So we're going to stop and we're going to break it down because it really is the crux of how the majority reached its decision in this case. So the 14th Amendment says that no state shall deny to any person the equal protection of the laws. And what the majority does here is say that when a law does not burden a fundamental right or does not target a suspect class, the type of analysis that's going to be provided by the courts is one that is called rational basis review. What does that mean? Does the law, in this case, the Tennessee SB 1 law, does it have a rational relationship to some legitimate end? And I continue to put this in quotations because that is literally how the law analysis is. Does Tennessee's law prohibiting transgender medical care to youths, does it have some type of rational, reasonable relationship to some legitimate end? Now, how does the court reach this decision? Well, it relies upon the evidence that has been provided by both sides throughout the course of the litigation. So, when you do a rational basis review, which the majority applied in this case, it comes to the conclusion, it being the majority, that even a improvident decision, meaning even maybe not such a good decision that's reached by the court, will, quote, eventually be rectified by the democratic processes, period. What does that mean? That means that even if the majority in SCOTUS comes to a bad conclusion, which was reached here, in my opinion, even at a bad decision, then the democratic process, meaning voting can cure this later. How? By the electorate putting into the legislature of that state new people that will enact new laws in that state. But that's how the court says, even if we make a mistake, even if we come to a crappy conclusion, just go ahead and elect the right people into your state legislature and you'll get to the right result eventually. Okay. In my opinion, that's not how we get there and it's wrong, but let's go on. And again, we're still in the majority opinion. Quote, we are asked to decide whether SB 1 is subject to heightened scrutiny under the Equal Protection Clause. We hold it is not. SB 1 does not classify on any bases that warrant heightened review. Stop. So remember, we just talked about and we learned about rational basis review. So the plaintiffs in this case, they're saying, look, this law should not be considered on the basis of rational review. It shouldn't be that low standard of rational basis review. This law should be subjected to something called heightened scrutiny or heightened review. Why? Because it's a law that implicates sex. It's a law that deals with sex. And because of that, a heightened scrutiny analysis must apply. But the court in its majority says, we do not think that this Tennessee law classifies on any basis of sex, and so it doesn't warrant that heightened scrutiny or intermediate review. So the strict constructionists, meaning the justices or the judges that are looking at just the language of the statute itself, they say, on its face, SB 1 incorporates two classifications. First, SB 1 classifies on the basis of age. Healthcare providers may administer certain medical treatments to individuals ages 18 and older, but not to minors. Second, SB 1 classifies on the basis of medical use. Healthcare providers may administer puberty blockers or hormones to minors to treat certain conditions, but not to treat gender dysphoria, gender identity disorder, or gender incongruence. Classifications that turn on age or medical use are subject to only rational basis review. Stop. Okay. So, in order to justify the use of a rational basis scrutiny by the majority in this case, they are saying that this Tennessee law only classifies on the basis of age and on the basis of medical use. They conveniently ignore the fact that the medical use component of this law obviously deals with gender dysphoria, gender identity disorder, or gender incongruence, meaning this law has excluded medical providers from being able to help minors when they suffer from those particular medical conditions. So it's the convenience of the majority to be able to ignore the fact that there are certain medical conditions that are being excluded by this Tennessee law. And so the convenience comes because they say, look, then that means that we can apply that lowest analysis of just rational basis review on this particular law. Next, let's fast forward a little bit, right? Next, the majority says the following. The majority says the plaintiffs separately argue that SB 1 warrants a heightened scrutiny analysis, remember that intermediate analysis, because it discriminates against transgender individuals who the plaintiffs assert constitute a quasi-suspect class, meaning it is not a totally suspect class that allows for this heightened scrutiny, but it's kind of a suspect class. But the majority says, quote, this court has not previously held that transgender individuals are a suspect or quasi-suspect class. And this case, in any event, does not raise that question because SB 1 does not classify on the basis of transgender status. Stop. Okay. So again, the majority contorting itself to be able to justify its majority opinion says the following. because the law in Tennessee doesn't classify explicitly on its face on the basis of transgender. Although, excuse me, how is that possible, people? If the excluded medical care, again, is gender dysphoria and gender incongruence and others, gender identity disorder, how are you saying it does not deal with gender or transgender status? But anyway, the majority says that because it, as in the Supreme Court, has never before said that transgender individuals are a suspect or quasi-suspect class, then you know what? Plaintiffs, you're wrong. You're wrong and we're right, the majority says. The majority says it's rational basis review. It's not heightened intermediate scrutiny. Okay, let's move forward. So then the majority says, look, we understand that in 2020, the Supreme Court reached a decision in Bostock versus Clayton County. In that decision, we, as the Supreme Court, held that an employer who fires an employee for being gay or transgender violates Title VII's prohibition on firing an individual because of their sex. But they're saying that Bostock, that decision, that precedent, doesn't apply here. And we say, and this majority says, look, we've never considered whether that Bostock precedent reaches beyond Title VII, and we're not going to do so here. For the reasons we've already explained, changing a minor's sex or transgender status does not alter the application of Tennessee SB 1. Okay. So again, that is the majority opinion's rationale for not relying upon the precedent of Bostock, which is the Supreme Court's own precedent in this case. So in the end, the majority says at this point, and despite the presentation of the evidence from the other side and the arguments being made by the other side, the Equal Protection Clause, quote, does not resolve the disagreements. Our role, nor does it afford us license to decide them as we see best. Our role is not to judge the wisdom, fairness, or logic of the law before us, but only to ensure that it does not violate the equal protection guarantee of the 14th Amendment. Having concluded it does not, we leave questions regarding its policy to the people, their elected representatives, and the democratic process. The judgment of the United States Court of Appeals for the Sixth Circuit is affirmed. And you have a concurrence that's filed by Justice Thomas, of course. You have, which I'm not going to do in this video with you guys. You also have a concurrence that was done, and I'm moving as fast as I can, folks, by Justice Amy Coney Barrett. And then and then you also have a concurrence by Justice Alito, because you know everybody's got to dip their toes in this freaking water. So let's skip forward to Justice Sotomayor's dissent, because her language is strong, powerful, and dead on correct on the law. Alrighty, so quickly, Justice Sotomayor in her dissent, with whom Justice Jackson joins and Justice Kagan joins, as to all but one part, but that's not the relevant thing. So let's talk about what Justice Sotomayor starts with, because this is the important part. She says the majority got it wrong on the law. To give meaning to our Constitution's bedrock equal protection guarantee, this court has long subjected heightened judicial scrutiny to any law that treats people differently based on sex. If a state seeks to differentiate on the basis, it must show that that sex classification, quote, serves important governmental objectives and that the discriminatory means employed are substantially related to the achievement of those objectives. Such review, known as intermediate scrutiny, allows courts to ascertain whether the state has a sound, evidence-based reason to distinguish on the basis of sex, or whether it does so in reliance on impermissible stereotypes about the sexes. Fast forward a little bit. Justice Sotomayor in her dissent says, Tennessee's law expressly classifies on the basis of sex and transgender status, so the Constitution and settled precedent require the court to subject it to intermediate scrutiny. The majority contorts logic and precedent to say otherwise, inexplicably declaring that it must uphold Tennessee's categorical ban on life-saving medical treatment so long as any reasonably conceivable state of facts might justify it. Thus, the majority subjects a law that plainly discriminates on the basis of sex to mere rational basis review. By retreating from meaningful judicial review exactly where it matters most, the court abandons transgender children and their families to political whims. In sadness, I dissent. I mean, really, folks, I don't even need to read more, although I invite you to do so, and I will post the opinion for you in the comments section of this YouTube video. But this really, Justice Sotomayor really nails it on its head. It is a politically motivated decision by the majority in this case. It is politically convenient for the majority in this case to ignore the fact that Tennessee's SB 1 law is specifically targeting a class of people, that being transgender children. So, the hypocrisy is rank. The Supreme Court of the United States, its majority of conservative justices, they like to say that they are strict constructionists, that they look at the face of a law and they rely upon just the language of that statute in order to reach its decisions. But the hypocrisy that comes from the majority is that they are clearly driven by political motivations. They do not want to support transgender people, and they certainly do not want to support transgender children, transgender minorities, even though they know that the evidence and the science supports the need for the medical care and treatment that is provided to those that are suffering from diagnoses of gender dysphoria, gender identity disorder, and gender incongruence. Those are medically proven conditions. And yet the majority says, because it doesn't fit squarely within their conservative minds about what constitutes sex or sexual classification, the majority says, we're just going to uphold this Tennessee ban. Now, the reality of doing so is the following. There are several states across our country that have enacted similar bans to those that we see in Tennessee. And so as a result of the Supreme Court decision, now this Tennessee law being upheld, this means that those other bans are going to be upheld in those other states. The highest court of the land has spoken, has done so in a hypocritical tone, has ignored precedent and the appropriate legal analysis that must be applied to laws that implicate sex. And they've done it now, and it's going to be harmful to hundreds, if not more, thousands of children. I'm telling you, since when did the Supreme Court of the United States think that it could substitute its judgment for that of doctors? I don't know. I guess when it deals with things like abortion and mifepristone, the abortion pill, and now transgender care for minors, I guess that's what they think it is. Folks, I will provide further analysis, but I wanted to get this to you immediately, and I appreciate your patience as we walked through this together. Be mad, be outraged, demand accountability. You know I am. I'll see you on the other side. Katie Phang here. The truth matters now more than ever. So hit that subscribe button so you don't miss a thing. Thanks for watching.